of escrow or in the middle of a purchase or even a refinance and a real estate transaction, and they all of a sudden realize the person on title, you know, there might be some issues on the title. The biggest one that we often find is the one where, my uncle is on title with me and he's passed away, or my mom is on title with me and she's incapacitated. She's in a care facility and she no longer has capacity. And they'll say, what do you mean I can't refinance this? Or what do you mean I can't sell the property? You know, she wants me to. Some examples like that are things that come up when title and property transactions are occurring. The one that's the most concerning that everyone should be mindful of is husband and wife. I do get calls sometimes when there's an ongoing refinance, or maybe they're in the middle of a purchase or sale transaction. Something happened to one of the spouses and they're calling me and asking, well, what can we do? They signed all the initial documents and all that's left is the final, final escrow documents for the deal to close. Why can we not close now? And so when I get those types of calls, it alarms me and tells me that the individuals that are in the middle of the transaction do not have an estate plan. Okay, so here's the thing. A lot of people out there think, oh, this is not for me. I don't need to listen. I don't have that much stuff. Let me just tell you my elevator speech and keep it super, super simple as possible. Who needs a revocable trust? And then I'll talk about what a trust is and sort of how it functions. So in California, we actually live in the worst state in the nation with probate, the most strict probate rules. Our probate system is the most arduous and costly. I'm always embarrassed to share that, but that's the reality. So people who need a revocable trust is anyone with money over $166,250. That is literally the code. It's in the California probate code. If you have a bank account that is $167,000 and you pass away and there's no beneficiary on that account is going to trigger probate court. Okay. Who else needs a trust? Anyone with real property. My biggest pet peeve, if you don't mind my sharing, is, people be like, oh, I don't need a trust. I don't have anything. And then as I start talking to people, they go, oh, well, my mom's property is in my name. And I'm thinking, oh my gosh, that is so scary. And I look at them and I go, okay, well, when you die, that entire property is going through probate. So if you own real estate in California, it is suicide not to have that real estate held in a trust. Are there exceptions? Yes, there are. I'll talk about that, but I'm talking big picture here. Secondly, anyone that's a business owner needs to have the interest and shares of that business under the umbrella of their trust. I always refer to the umbrella of the trust. I see it like protection. An umbrella protects us from the rain. My umbrella analogy in the trust discussion is protecting you from probate court. Here's the crazy thing that people don't realize. Having an estate plan. So an estate plan is a series of legal documents. They're all private documents. It's between you, the individual, and the state of California. Okay. So oftentimes it's between husband and wife and the state of California. Okay. Siblings can't have a joint trust. Parent and child cannot have a joint trust. So it's either I have a single trust, or as husband and wife, I have a joint marital trust, or same-sex couples that are married can have a joint trust. Okay. But when you hear attorneys talking about estate plan, it's a series of legal documents that is going to basically help protect you. We create the legal documents, and it's an umbrella of protection over you, the person, your spouse, your children, and all your assets. Now, there's a process of how all this works in terms of how you get the assets under the trust, but in essence, real estate related. If tomorrow I go out and create a trust, and this home that I live in currently is in my name, right? You look up the deed in county recorder's office and it says Shadi Shaffer. Let's just call her a single woman. Okay. She owns the property. Okay. The moment I create a revocable trust, a good attorney, a thorough attorney will transfer the deed of my property from Shadi Shaffer now to the Shadi Shaffer Trust or the Shaffer Family Trust, whatever I name my trust. Why is that important? I'm literally going to go pick up my kids in a few hours. And here's the thing, none of us have a magic ball. I could get sideswiped by a car. I could die. If I die, that property now is going through probate. No one in my family could sell it. They cannot refinance it. They can't even put a tenant in it unless they had the ability to do that. The only ability to do that, because I'm a single woman that owns this property, is through a trust. How a trust works is it puts a trustee in charge. Okay. I am the trustee of my trust. I'm the captain of the ship when I create the trust. So you don't lose control. A lot of people freak out and think, oh, I'm going to lose control. You don't lose control. So what happens is it's only when I'm ill or incapacitated or I've died will my successor trustees step in. Why is this so important? Guys, if you don't pick your people, guess who gets to pick it for you? The court system, the judge. Why would you want to let them decide who in your life is well equipped or looking out for the best interest of you or your children or your loved ones? You know, a judge doesn't know those things. So a trust is sort of, I call it a vault. It's like putting your home, if you will. Think about our homes, and I can hold my house in my hand and I'm putting it in this beautiful vault. Okay. It's a vault of instructions. I often call it a love letter. Okay. It's a love letter we leave for our families. And unfortunately, the state of California has their own guidelines and their own instructions for us. Why is probate so crazy and so nasty? First of all, in California, probate takes 1 to 2 years to go through. Right now, on average, it's about a year and a half, especially now because of COVID. So just so that you guys are clear, if I was a single woman living in this property, my property could sit there for about 6 months till someone appointed through the court is allowed to even sell it. Minimum 6 months. I'm telling you, it doesn't happen faster than that. From the moment someone files a probate, the first hearing right now is out 4 months. That's a minimum. By the time you get the court documents and papers, it takes another month or so. So you're looking 6 months before you could actually list that property for sale or lease it or whatever. So you understand that that is a huge issue. The other thing that I want to keep in mind is that when you go through probate, everything is public. So now everyone knows all your business. They know the make and model of watches, how many jewelries and diamond rings you had or didn't have. And what's worse is if you have minors, maybe that's not children, maybe it's godchildren, maybe it's nieces and nephews, they're going to know how much you're leaving to them. That's all public record. So, you know, James Gandolfini, the soprano actor, Paul Walker, the Fast and Furious actor, those gentlemen died in California and their entire estates went through probate. Everybody knows. You can look it up. If you know how to do it, you can look it up. Paul Walker, how much was he worth? He's got a tiny little daughter. She's under 18. She's a child. She's a baby right now. She is going to inherit every penny of his estate at age 18. With no protection, no guidance, nothing. I sit in front of you today and I've got 2 little boys, 8 and 4. My trust currently says my boys get money at age 25, another percentage at 30, and then another percentage at 35. That's just an example. You could design your trust however you want. You want your kid to get it at 18, you can. But the idea is that people, when they earn, by the way, statistically, when people inherit money, 70% of it is spent in the first year, despite the age of the person. So it doesn't matter if they're 60 or 20, 70% of the money is being spent on the first year. Now, granted, they go and they buy a house and stuff. There's some outliers there, but it's important that people are aware of that. The other thing that an estate plan, so a full comprehensive proper estate plan includes a revocable trust, a portable will, power of attorney for finances, and healthcare directives. There's a lot more other stuff in it. I'm going to just focus on the main points. Why am I bringing this up? It's not just about avoiding probate. People think, oh, I'm not worried about dying. Okay, no problem. What about if you get sick? What about if you get in a car accident? What about if you get into a stroke? What about if you're in a coma? I'm poster child for those stories. My father-in-law, bless his heart, and may rest in peace. At 62, he was in the middle of a property purchase and he bought his RV and he had a tragic car accident. He was in a coma for 4 months. The only way his wife was able to finalize that purchase transaction on the real estate was because they had an estate plan. She used the financial durable power of attorney to sign on his behalf to do that transaction. Think about it, you guys. You could be a married couple living 50 years together, and you do not have an automatic right to make decisions for your spouse. Not legal, not financial, not health. It is not automatic. When I tell people this, that I think Andrea just said, wow, it's stuff people don't know. I get it. You don't know what you don't know. I'm here to share that with you. The Nest team is amazing for putting these educational series events on, and it tells me how you guys are professionally. Your caliber and your commitment to your clients is next to none. I mean, really, I'm impressed. And so by putting these educational talks on, they're educating you guys on the importance of estate planning. They're not just focused on, hey, let's do your real estate transaction. Let's do your next purchase. Let's do your next investment property. People think it's unfortunate. People today think, oh, in order to have a trust, I need to have a lot of assets. I just got done telling you a simple business, an LLC, a corporation, any money over $166,000, any ownership in real estate. If your name is on a parcel of property in California, it needs to be in a trust. Okay. So for those of you out there that are married couples, you go, it's, we own it as joint tenants with right of survivorship. If I die, my wife gets it. Okay, I hear you. But what about the scenario I just talked about my father-in-law who had a tragic car accident and they're in the middle of their purchase? If my mother-in-law didn't have the full estate plan, she wouldn't have had the power of attorney to utilize it, to sign to sign the escrow documents, to sign the final purchase documents and agreement. Not to mention she had the healthcare directives in place too. My father-in-law's story is a tragic one. He lost his dominant left arm. She had to decide, okay, amputate it, before the infection spread. Unfortunately, my father-in-law's story, although it was a successful story from an estate planning perspective, and for my mother-in-law, it made all the difference in the world that she had those tools, very necessary tools, to just function with, continue functioning her life or their life together. Unfortunately, he lost the battle, and 7 months later, he passed. But those estate planning documents came up even then. Okay, she had the document for life support to stop life support when his lungs were collapsing. And then she had the documents that allowed her to do his funeral planning and funeral arrangements and memorial service. So, we're all sitting here going about our lives. And, I know it's a drag to call attorneys. If there's any attorneys listening, I apologize, but a lot of our drags to call, let's be honest. And I think sometimes we can overwhelm. And when we're educating, the information can be very overwhelming, and it just causes us to do what? Nothing, right? The other issue that comes up is cost, and I'm here to talk about cost, no problem. Here, look, in my firm, our cost is very different. We're not a trust mill. We're not a transactional firm. When clients come through our doors, they're looking for a family trust advisor for life. Okay. These are clients that want to be able to call us and ask us questions. Changes have come up, new children are added, things have changed in their lives. One of my clients just contacted me this week, and they've been my clients for 6 years. They have a new son, and he's got like 10 new companies. Those companies, I have to do some additional documents to make sure it's under the umbrella of their trust. Okay, so those are important things to keep in mind. In my firm, trust pricing ranges between $3,000–4,000. A lot of people think, oh my gosh, that is crazy. It is crazy. You're right. It's a cost. You could spend that money, go get a handbag, women, ladies, men, and ladies, go travel with that money, right? That's vacation money. I get it. I don't come from a family of attorneys. I'm the first in my family to go to college, first to go to grad school. My mom's a beautician. My dad's a contractor. I get it. But here's the thing. And here is the point that's the most important. If you could take anything out of this session today, it's this. The entry fee for probate is $3,000. Just the entry fee. It's like a ticket to go to Disneyland. Hello, Disneyland. We just want to come inside. Hello, probate. We just want to come inside. Average cost, $3,000. Okay, that's just to get inside. We all know how expensive it is inside Disneyland, right? Okay, so check it out. I'm going to give you a perfect example of how for you to, at least it's more palatable to think, oh, $3,000-$4,000. Okay. And by the way, it's a one-time fee that should really last you for life. A trust is such a powerful tool that it'll last your life, the lives of your children, and even the lives of your grandchildren. Like, it can go that many years. Okay. And remember, there's all these different components to it. So it's not just about avoiding probate. It's also about avoiding conservatorship court. If you have children, it's about avoiding guardianship court. Okay. Having appointed guardians for your children. It deals with your health. It deals with your bank accounts. It deals with your employer benefits. Can your husband or spouse, wife just call the employer and go, oh, it's my wife of 50 years. I need to access her 401k for rehabilitation, or we need extra money because now we don't have income. The lawyer is going to be like, do you have the legal documents that say you could do this? And if you don't, you're SOL, you're out of luck. You're not going to have it. So let me go back to the cost. And by the way, there are lower cost options out there, you guys. There are attorneys that do trust for $2,500. I have a dear colleague that does it for $1,500. Everybody's got a different cost plan. There are some that charge $6,500. Okay. So I get that the pricing's all over the place. The only thing I'm going to say about pricing before I move on is just be educated on what you're getting. Okay. Some firms charge hourly, some firms charge a flat fee. When you are talking to an attorney, ask, what does this fee cover? It should be very, very clearly laid out. In my firm, when you get an initial information and overview about estate planning, you're getting, this is everything we do, and this is the cost. Okay, so it's really clear. All right, let me go to my favorite part. Inside Disneyland or inside probate, how much money are you going to spend? Okay. Probate fees. So the initial, when I said it on average, the entry fees, $3,000, that's just filing fees, publication fees. I won't get into the details of probate. But here's the crazy part. Probate fees in California are based on code. So here's the good news. Attorneys don't get to set the fees. Thank goodness. Okay. So you can interview 10 attorneys and it's not going to matter because it's the same across the board. The probate court goes, oh, Shadi was worth this much. These are the assets of Shadi's going through probate. Let's put it into the code. It goes into the code. The first 400,000 is times 4%. The next 800,000 is times 3%. You get kind of the idea. I'm just throwing out numbers here. Let's take the example of my home. The market value of my home is $1 million. It's shy of $1 million, but it's $1 million. Okay. And a lot of properties in California, that is not odd, right? We're looking at 700, 800, 900, $1 million or more. Now I owe my lender $700,000. So my equity is $300,000. Okay. So when all is said and done, let's just say it's just me and my two boys are going to get my estate. They'll split the $300,000. Okay. Right. Here's the crazy part. Probate fees are not based on my equity. Probate fees are based on the market value. So when you plug in the $1 million amount, guess how much guess how much probating just $1 million asset in California costs? You guys are going to freak out. $31,000. I'm going to just wait. Crazy. You guys, I make $31,000. I'm on the case for a year and a half, sometimes to 2 years, but a year and a half minimum. That's the fee my firm gets. We get $31,000. The first probate case like that I had was 8 years ago. Maybe it was 9 years ago now. I was like, wait a minute, what? Because I'd done smaller probates, 300, 400, 600. It hadn't gotten to that point. And when I plugged in the number, don't get me wrong, I was like, wow. But that's not how I want to earn my fees in my estate practice. I want to help families and clients protect themselves and be proactive. Why? It's sad to say, sorry, you lost your loved one, or sorry, your mom died, or sorry, your husband passed away, I just had a client whose husband died at 57. That's so young. I'm telling you, I don't want to have, I don't want to go, there's not much you could do right now. I don't want to tell a sibling, you have to pay for all your sister's expenses and funeral expenses and everything else because you can't access her bank account, her retirement. You get where I'm going with this, right? So that's why it's so important to have estate planning done. So when I charge $3,000, $4,000, you can see why. And here, by the way, I mess up, my client's going to sue me for way more than $3,000-$4,000, right? If I mess up and don't transfer an asset into that trust, and that was part of the agreement, well, they have a malpractice case against me, and they can sue me for the cost of probate and all the other damages that they have. So I always try to explain to clients that, you have to understand, I had a guy who had 10 properties. His trust, I think, ended up costing him $6,500. Maybe it was $7,500. I don't know. You guys know this. Every deed I file is $100. There was at least $1,500 of just hard costs of just filing fees to the county recorder's office. It wasn't even my firm's fee. So, there's a lot involved, and I don't want to get too crazy into the details. But estate planning is your lifeline. After life insurance, here's what I tell people. You don't get auto insurance hoping you get an auto accident, do you? You don't get health insurance hoping you get sick. You get these things so when life happens, you're protected. That is estate planning. And by the way, I do want to mention one last thing before I wrap up. A will in California will not avoid probate. Because you're named in your brother's will does not allow you to be able to manage stuff for his kids, access his bank accounts, do any of that for him. He might have left you the home in his will. You can't go to escrow and to the Nest Group and say, yeah, let's go, let's sell this property. You don't have the right to do it. The only thing that gives you the right is if it's titled in your name and you're alive and you can make those decisions, or it's held in a trust and you're appointed the trustee of that trust and the asset is in the trust. By the way, I will tell you, I got 3 referrals since the beginning of this year. Actually, most of them was just last month. 3. They all had a trust attorney. For whatever reason, I think they were on the low end. I think the attorneys were like, look, we'll transfer the home, but everything else is on you. One of the wives, her husband was 57 years old. He has a financial practice. She's trying to sell it today. She can't sell it. Legally, she does not have the right to sell it. It has to go through probate. She saved what? Maybe $1,000. I don't care. Call it she was trying to save $3,000-$4,000. Was it worth it? No. She's not going to be able to sell that practice. It'll take at least 6 months before she could actually sell the practice. And by the way, when she sells the practice in probate, the money's held in probate. Guess when her and the kids and the family get the money? When probate finishes. I've got clients where the family's money is sitting in the estate account. One client called me, she needs it. She needs the money. She's old. I'm like, I'm sorry. She's not allowed to touch the money until final court order is given and she can get it. Now, there's some occasions where you can go in and ask the court, but I'm telling you, the courts, everyone's asking them all the same thing. If they make exceptions, what's going to happen? Right? So the courts are pretty adamant. Like, these are our rules. You should have done your plan. Not my mistake or my problem. Now we have to govern it for you. Okay. So as the Nest team, you guys know the importance. You guys do things every day. You guys have clients that are buying properties and things. So this subject is super, super important. So just make sure you guys, I think this is great. And I thank you guys for giving me the opportunity to speak today. I really commend the Nest team. Thank you guys.
Thank you so much for joining us, Shadi, and at least enlightening those of us that are on the call today with the importance of an estate plan. And the reason why, like Andrea said, the reason why we do these informational sessions is because we see the horror stories for when the estate plan is not in place, and we get a call from a client where they had a spouse pass away or a parent pass away, and then they don't know what the next steps are. And if we find out that they don't have a trust, then we're the ones delivering the unfortunate news that they're going to have to contact a probate attorney and to go through that process, which is, it's emotionally taxing at the same time that it is incredibly financially expensive. It's a lot to grieve the loss of a loved one at the same time that you have to go through a court battle to try to liquidate the estate. It is not a fun experience for the clients that we've had that have had to go through this. So we'd rather be preemptive in educating our clients about the importance of establishing a trust and making sure that you put your property in the name of the trust when that becomes appropriate. it's gotten easier now in the real estate field to even purchase a property in the name of a trust. That used to be a problem with lenders because your trust isn't necessarily an entity that can assume financing. But you can do this almost immediately or during the escrow process, where you can purchase in your individual name, and then you can transfer the trust into your, or you can transfer the property into your trust with a quitclaim deed at the same time when you're purchasing. So it's important that you know, especially when you refinance, that's the thing that a lot of people don't realize. If you have a good lender, they're going to make sure that they help you do that. So if you refinance your home and your home was in a trust, most of the lenders take the property out of the name of the trust. They do the refinance in your personal names, and then it should get re-recorded in the name of the trust. But that doesn't always happen, which is a huge exposure point for clients. So we want to make sure that everybody understands it's important that you double check what your recording is. If you did a refinance, to make sure that that property was re-recorded in the name of the trust. And with these interest rates that we've had recently, there's been a lot of refis. So make sure, and if you ever have a question about that, or if you ever wanted to find out how a property is being held in title, the good news is we have access to public records where we can pull that very easily for you. So if you wanted to find out, you know, if you have mom and dad and you don't know if they recorded their property in the name of their trust, or if it was refinanced recently, or yourself, if you're not sure that it got, you can give us a call. Any of us on the call, you've got Manya, myself, Andrea, Kirstel, we're here to help you pull those records just to make sure. And that's a huge impact, because you could find out that that's an exposure point that you need to correct. So it's a quitclaim deed that needs to be drawn up and then recorded with the county recorder's office in order to make sure that that property gets put into the trust.
Mhm.
So we're definitely here to help you with that.
Great point. Very smart. And by the way, lenders or escrow, sometimes they'll say we can't put it back in the trust, or we can't put it in your trust. That's not true.
They can.
They can, yeah.
So
So
just an extra step that they don't always like to take. So
they don't always like to do, exactly.
Yeah. Well, and I can tell you from experience, and we'll open this up to question, but who you work with matters. Not only as a realtor, but your trust attorney is, I mean, that's a huge difference. I've been on the estate planning council in Long Beach for many years. And the people, the quality of the people that continue to educate themselves, and like Shadi, who are educated and continue to do continuing education about the new changes about trust law, they have a better comprehensive understanding about how to do an estate plan. If you're trying to save money, like Shadi said, and you go to somebody that's going to give you the lowest fee to do the least amount of work to establish a trust, there could be pretty big exposure points. And I've had a horror story where there was an estate plan done, there was a very simple trust done, but there were some things missing, and so the trust was contested by a family member. So if it was a well-written trust, that wouldn't have happened. So, again, it's who you work with matters. Finding professionals who have great reviews, like Shadi, like we do, because we really care about our clients.
Yep.
We're here to make sure that we're trying to help you protect your family, protect your asset. We're here to build lifelong relationships, not to just collect fees and turn and burn to the next one. So again, Shadi, thank you so much for being willing to donate your time to share some of your insight and experience with us today.
Oh, my pleasure. Thank you for having me. And if anyone has any questions, you know what I'll do is I'll put my contact information in the chat, just in case. I'm happy to always answer questions. Our biggest focus is educating clients and families, and you don't even have to hire us. We're just happy to educate. If someone's done their trust because they heard me speak, I feel like I've done my job. I mean that with all my heart. I want everyone to be protected, because when you lose a loved one or someone's sick, I've been through it. It's the worst experience to not have those things, the tools in place you need. It's the last thing you want to think of at that time. So thank you guys for having me.
Yeah, I know we have a question from Bev Rosen, who logged on a little while ago. Hi, Bev. I don't know if we can hear you, but you've got your hand raised. if you want to put a question in the chat, if you're muted for whatever reason and you can't ask a question live, you can put it in the chat. Otherwise, let us know what your question is and we'll get back to you. Emerson, your hand's up. Can you hear?
Good.
Can you hear me?
We can hear you now. Yes.
Okay. First, thank you so much for putting this together. This is what I was looking for, this information. I had no idea where to start. This has been great. You've already answered a lot of my questions. One question I have that I got a little bit confused is, okay, your firm, the 3,000, 4,000, what does that exactly cover? Is it a one-time thing, or is it like lifetime, or like what if I need to make a change next year to that? What are the costs, and or how does it work?
Yeah, that's a good question. So our fees are based on, we do everything in your estate plan. So if you own a company, the company is going in the trust, bank accounts, assets, the real estate. Be careful. That's really just for one real parcel, that's one for one property. If you've got additional properties, there might be additional costs, but notary fees are included. It's a one-time fee that we charge. The biggest takeaway is if you're in the middle of a real estate transaction or you're refinancing in the future, we will always guide you at no charge to make sure the property continues to stay in the trust. So we're very proactive like that. We do free review meetings every year. And basically what the retainer provides, in addition to the actual plan, is lifetime guidance and no additional charge. So the clients that I met, I was referring to, I did their trust 6 years ago. We had an hour meeting this week. They didn't get charged for that. And we're doing some updates. Now on the updates, it used to be that we didn't charge, but as we've gotten larger and it's getting harder and harder to manage all that, we do charge a $350 fee to make changes, but we really keep the fees super low. One of the changes that they need is like literally $100 change. I'm not even covering my time. I just cover the cost of my firm. For existing clients, my biggest goal is that we continue to stay there for you guys, not just when you need us to design and make the trust, but throughout the years when your life changes. So I hope I answered it, but there's a lot more involved, Emerson. It's a revocable trust, pour over will, power of attorney, healthcare directives, living will, HIPAA form. I mean, it goes on, and I don't want to overwhelm people on the details. But if you call, we've got a packet we could either mail out or email to you, and it gives you all that information. We also have videos online on YouTube if you'd like to learn more about the subject.
We just put your information, Shadi's information is in the chat so that you can see her direct phone number and the website for her firm. So if you want to take that down, it's in the chat box. You should be able to see that directly, and we'll share that with you again when we send out the link of the recording for this session. So any other questions?
I'll go back to Bev and Beverly.
I think she's having audio
Okay.
problems, so I don't see her anymore.
You can email us the question too. We can connect you with Shadi as well if you want to.
Yeah, I'm
Perfect.
happy to answer questions via email too.
I
Absolutely.
have another question. When transferring a property to like a trust, does that affect future financing if that property is a investment rental?
That was touched upon. So there's a lot of education that goes into knowing what estate plans and trusts are. The trusts that I'm talking about primarily are revocable trusts. Typically, a revocable trust is really you owning it. It's not a separate entity, so be mindful of that thought process. It is literally you and your social. So, Emerson, typically what happens if it's an investment property, as it was explained earlier, while you're in the middle of the escrow transaction, they take it out for a few seconds, fund the loan in your name, and then they put it right back into the revocable trust. Hopefully I answered your question.
Yep.
The trust is not getting financing. You, the person, is still getting financing.
Got it.
And Shadi, just as an aside, because a lot of people, if it's a simple trust and it's you and your social and you're doing a revocable trust, you don't necessarily get an EIN number for the trust.
Absolutely not.
So it's just you and your social security numbers, but there are trusts that have an EIN number, and then you have to file a separate tax return for that trust. So those are a little bit more complicated.
Those are typically what we call irrevocable trusts. Yes. When you do a revocable trust, all it is, it's a private contract. It's just an agreement between you and the laws of state of California. It's a private document that you keep, your family can have when they need it. Your trust attorney keeps a copy of it. Nothing is filed and nothing is public. It is key. Something to keep in mind too, when you're in probate, you've just opened up a public court proceeding, letting anyone that has a claim against you, or especially creditors that have claim against you,
Yeah.
easily file a one-page document, and you have to give them every penny of the money you owe them if it's a valid debt.
From the
I'm not
state,
saying
yeah.
that if you have a trust, you don't have to pay your debts. I'm just saying you have more leveraging power because it's private and the creditor doesn't know how much you have. So then they have to decide, oh, do I spend the money to go after this person and sue them and so on. Whereas in probate, you're just a sitting duck and you're making it super easy for the creditors.
Well, thank you to everybody who logged on today. And thank you again, Shadi, for your time.
Thank you guys so much. I enjoy these events with you guys, and I appreciate it so much for you guys doing that for your clients and the public. Thank you,
Great.
everybody.
Thanks
Have a
again.
great day.
Take care.
Thank you. Bye,
Thank
Shadi.
you.
Thank you.